All right, hopefully everybody is in the room. So again, my name is Jeff Newby. I'm the manager of the Workers' Compensation Department over in New Jersey. Dave Green is over in the Fort Washington Drescher area. Been to his house several times. I know exactly where he is. And Dave is one of our senior Pennsylvania Workers' Compensation partners. And Dave and I are going to be talking to you today about the dual jurisdiction issues between Pennsylvania and New Jersey workers' compensation. Dave and I have had this discussion with our clients for about 30 years. It is aging us, but it is what it is. So we've been discussing this topic, and I think it's one that hopefully will be of interest to you guys that have signed up today. And but you run into these issues. So Dave, take it away.
Yeah, before I get started, I wanted to mention that we have two people from our tech team on the line. So if you have questions, please feel free to put them in the chat. Kristen or Chelsea will direct them to us. We will try to get to them at the time when you ask them. And if for any reason we don't get to them during the program, we will have them and we will email you after the fact. And hopefully, as I do this slide, you're able move the slide, you'll be able to see everything. So anyway, with that, we want to talk about our dual jurisdiction experience. This issue, and Jeff has said it is what it is. For me, at least, it is one of the most frustrating conversations that I have to have with clients because it doesn't make sense and it seems unfair where one person could suffer an injury in New Jersey and work out of New Jersey and only be entitled to Jersey comp and the protections of New Jersey, when that same person, if that person is directed over to Pennsylvania, gets injured in Pennsylvania, all of a sudden that person has protection of both states and potentially is entitled to benefits in both jurisdictions. That's incredibly frustrating to most clients that I speak with. Jeff and I have been fortunate enough over our careers, Jeff more than I, as he'll speak about in a minute, but in the mid-90s, I'd say, when Jeff started our New Jersey practice at Weber Gallagher, I was assisting Jeff. And I did everything related to New Jersey comp for about 3 years. I was practicing Pennsylvania and New Jersey. And while admittedly, if you gave me the permanency chart, I would not be able to read it. I'd recognize where that bump or hump or whatever you call it is. I recognize where the issue is, but where that is. But what I do know is I understand the difference between the states, and I understand the issues that are relevant, and I understand how, in cases of dual jurisdiction, if I have a case in Pennsylvania or if Jeff has a case in New Jersey where there's dual jurisdiction, how to manage those states collectively. So I only handled New Jersey comp for about 3 years. I've been doing exclusively Pennsylvania workers' compensation since, and Jeff will tell you a little bit more about his experience.
Yeah, my overlap is a little, as Dave mentioned, a little longer, a little larger. I did Pennsylvania workers' compensation probably for almost 20 years, including a number of arguments before the Commonwealth Court, argued before the Pennsylvania Supreme Court. And then I handled both states for a while, and then slowly but surely stopped handling Pennsylvania workers' comp, focused entirely on New Jersey. And with New Jersey, I'm now certified by the Supreme Court. Took that horrible 6-hour exam, and we were still writing in blue books when I took it, so my hand was all cramped. And argued in front of the appellate division, also in New Jersey. So I have a lot of experience in both states, but just about the time Pennsylvania really went into WICAS and the forms, I dove out, and my staff was extremely happy when I did so. So that's my experience, kind of tails off quite a bit at that point, but that's where partnering with somebody like Dave is a huge help. So the key is issue spotting. The client has to spot the issue. We often spot it for you when we get a file. We say, be careful. This is a case where there can be jurisdiction in both states. And we can't put our blinders on to think that that's not possible. We need to let you know that it is possible. It happens on a regular basis, and we need to be aware of it and leverage it the best we can. And that's what we're going to be talking about today.
So some of this next stuff may be a bit repetitive, but we need to talk about it in order to explain what the strategies are to best minimize exposure when there is dual jurisdiction. So let's just briefly talk about how Pennsylvania works. Wage loss is generally 2/3 of the average weekly wage. No minimum, it's 90%. There is a maximum, 13.25 in 2024. You can get wage loss in Pennsylvania for life, very unlike New Jersey, or there's the 500-week partial with job availability or an impairment rating evaluation. You can get meds for life, even after MMI, absent a full recovery or a utilization review. And there's virtually, probably most importantly, besides the no permanency aspect, there's virtually no unilateral relief, meaning we can't stop benefits except if claimant dies for reasons unrelated to the work injury, if claimant is incarcerated post-conviction, another extremely frustrating thing for clients while someone's in jail waiting for their trial on armed robbery and they can't meet bail, that we have to keep paying workers' comp, and then the failure to return the LIBC reporting forms. Obviously, you can stop paying if claimant returns to work without wage loss. But again, you have the whole forms issue in Pennsylvania where there's no technical protection unless the proper form is filed. So that's the background of Pennsylvania. So when does Pennsylvania have jurisdiction? Obviously, any injury that occurs in Pennsylvania. It doesn't matter if you have a truck driver who works his whole life, 50 years, in Idaho and Washington exclusively. And his boss says, hey, Joe, I know you've only worked in Washington and Idaho, but do me a favor. I've got this route to the Jersey Shore. It's great money. Do you want to take it? And he says, sure, I'll take it. Stops at a rest stop in central Pennsylvania, trips and falls. Only time he's ever been in Pennsylvania. That's a compensable injury. Under Pennsylvania law, he has protection of Pennsylvania jurisdiction. Also, and this happens with truck drivers a lot, if their contract for hire is made in Pennsylvania, and it's the place of acceptance for where the contract of hire is. So if you're on the phone at your house in Pennsylvania, that's where the contract of hire is when you accept the job. But it has to be if the employee doesn't work from any location. Also, if the employee is injured, let's say in New Jersey, but there is a principal place of business in Pennsylvania where that employee regularly works at or from, then that individual, even the person could live in New Jersey, but if they drive over to Pennsylvania, there's like a truck depot in Pennsylvania. Every day they grab their truck from Pennsylvania, but then they deliver stuff to Pennsylvania, New Jersey, and Delaware. That person injured in Delaware or injured in Jersey is still going to have Pennsylvania jurisdiction because the employer has a place of business where the employee regularly works at or from. Jeff?
All right, so I'm going to take you through the benefits in New Jersey. I'm not as succinct as Dave on my PowerPoint, so I'll try and talk faster to not spend too much time, because I know who's listening into this presentation today, and you guys are all experienced. But first difference, New Jersey workers' compensation wage loss benefits are based upon 70% of the average weekly wage and not 66 2/3. Unlike that great form that you guys have in Pennsylvania, the 13 calendar quarters, we go by a 26-week wage statement. You won't find that in a statute or in a form. We pulled it out of the statute because the statute is poorly written, but that's what we do. We take an average of the 26 weeks prior to the date of loss, and we pay them 70%, and that's tax-free. Dave, you mentioned the PA max was like 1,300 and change in 2024. So I had to jump on real quick on the internet and pull up the max this year for 2024. I don't have it memorized. In Jersey, it's 1,131. It's always going to be a couple $100 less the max rate in New Jersey than in Pennsylvania. And that becomes important. We'll talk about it a little bit later, where somebody can get paid a higher rate in PA. And we don't have a minimum. So the 90% minimum we have in Pennsylvania, there is no minimum. There is no capping in New Jersey, where somebody with a really low rate won't get more than 90% of their average weekly wage. We do have a minimum, and the minimum, for instance, is 302 this year in New Jersey. So if they're making $200 a week, they're going to get 302 in New Jersey. I guess they're going to get 180 in Pennsylvania. So the laws are different in each state. We obviously know partial disability is alive and well in Pennsylvania. New Jersey, it's much less prevalent, much less of an issue. We don't have vocational rehabilitation like they do in PA. But the question about whether or not it exists, there's only one decision, and you can skip to the next slide, Dave. But there's that one decision from Judge Cox, like 12 years old now, but everybody knows about it. The judges know about it, the participants know about it. And if somebody's actively treating, the employer brings them back to work at a wage loss, there is such a thing as partial. There'll be motions filed seeking some kind of differential to get them back up at least to what they were making tax-free in their temp rate. So we really can't pretend it doesn't exist. Second benefit, medical benefits, much better in New Jersey than Pennsylvania, as you probably know. In New Jersey, you have the right to direct treatment under Section 15 of the statute for the life of the claim. So if it's a compensable case, you've agreed it's your case, you control treatment through the life of the claim. There's no 90-day window like there is in Pennsylvania. And in denied cases, you can provide the medical treatment while you're investigating the case, and you do so without an admission of liability. So let's go to the next slide. This is what's unique about New Jersey. This is what drives the litigation in New Jersey. Pennsylvania's litigation, Dave would tell you and agree, is driven by wage replacement, wage loss. New Jersey's litigation is driven primarily by this brass ring, this award they want to get at the end of their case. Med and temp are paid and they're over, and they're back to work. Sometimes they're back to work full duty, doing the same job. But in New Jersey, they're entitled to this thing called permanent partial disability, or permanent total if they're totally disabled. They're pretty rare, thank goodness. But permanent partial disability doesn't exist in New Jersey. So you can pay them all the temp and the med that's appropriate when they file a claim petition. And you're thinking, some people that are unfamiliar with New Jersey, I frequently get the question when I receive a claim petition, why did they file this? I'm either paying them now or I paid them and they're back to work. Why? Because under the statute, they're entitled to this permanent partial disability award for loss of function due to that knee tear, that bone fracture, et cetera. So those are the basic benefits in New Jersey. So similar to what Dave was talking about is when does our act provide benefits and coverage for an injured worker? And here's our bases. And there is no statute for this. Sometimes there's a statute for something in New Jersey where there isn't in Pennsylvania, sometimes vice versa. In this instance, there is no statute in New Jersey. It's all case law. So when the contract of hire is made in New Jersey, and that is the state where the contract of hire is accepted by the employee, that's enough for New Jersey jurisdiction. Popular case a couple of years ago, the guy did all of his work in New York. The office was in New York, but when he got the job offer, he was in his home in New Jersey. He accepted the job offer in New Jersey. New Jersey contract of hire gave him New Jersey jurisdiction. Similar to Pennsylvania, if the accident occurs in New Jersey, they absolutely have New Jersey jurisdiction. Some of these are a little bit like when a substantial amount of employment for the employee occurs in New Jersey. It's a little vague, but that's the case law. If they work at or from a location in New Jersey, they're going to get New Jersey jurisdiction. And if it's something less than that, the facts will dictate whether or not there's New Jersey jurisdiction, but the judges are very liberal in finding New Jersey jurisdiction. Keep in mind, residence alone in New Jersey is not enough. So if somebody lives in a suburb of New York, but they work in New York, or a suburb of Philadelphia, but they work in Philadelphia, they're injured in Pennsylvania or New York, and there's no other contacts in New Jersey, and they weren't hired in New Jersey, residence alone is insufficient.
Okay, before I really get into this, which is a frequently asked question, just to dovetail a little bit on what Jeff said, in case anyone's wondering, in case anyone doesn't handle a ton of Pennsylvania work. So the partial disability in Pennsylvania that was discussed, it can be at the same total disability rate with respect to an impairment rating evaluation, or it can be 2/3 of the difference between the average weekly wage and the earnings, whether the person's back to work at light duty at reduced wages, or if we found them work through, found that there's work available through vocational placement. So that's what happens in partial disability in Pennsylvania. And with respect to medical, it's a whole nother conversation about the first 90 days and how to manage that. That's for a whole nother program. But generally, after the 90 days, when a claimant, an employee gets representation, the attorney then directs that person to their own group of doctors. We have no control over those doctors at all. And this is a frequent reason why in dual jurisdiction cases, employees tend to choose Pennsylvania if they can, if they're out of work. Okay, so with that said, we get this argument all the time, right? The claimant's getting workers' compensation benefits in New Jersey, and they filed a Pennsylvania claim petition. And the client will call me and say, Dave, well, they chose New Jersey. Why do we have to do anything in Pennsylvania? So two reasons. One, typically, not all the time, but typically the employee is not choosing New Jersey. Typically, it is us, the employer, the insurance carrier, the TPA, who is deciding what state is the most appropriate one to accept the claim in. And we'll talk about that a little bit later too. And the only thing the judges care about, it doesn't even matter if the claimant has selected the location. All that matters is whether or not the employee has protection under Pennsylvania law. If the employee has protection under Pennsylvania law, it doesn't matter if they were receiving benefits in New Jersey, in New York, in Delaware. I have a client who every case they accept out of Nebraska. It's a trucking company. Their headquarters is in Nebraska. They have a whole staff of claims people in Nebraska. They always accept claims in Nebraska, whatever ones, regardless of where the person lives, where the incident occurred, it doesn't matter. However, they understand that if the accident occurred in Pennsylvania, they're going to be forced to move it into Pennsylvania. If the accident occurred outside of Pennsylvania, they have a really intricate contract in place, which is pretty hard to get around, where the employee is stuck getting Nebraska benefits. So it's kind of an interesting twist, but that argument, although it sounds good, the employee chose first, that argument's not going to work.
So unlike Pennsylvania, New Jersey does have a case on this topic about whether or not the employee has a choice of jurisdictions depending upon the facts of their case. And in this decision from 1980, the appellate division made it clear that an injured worker can have a separate workers' compensation claim in a different state for the same injury. And you don't like this phrase, and I don't like it either, but it's clear. It says they can seek the highest available benefits in each state. They can go back and forth. They cannot duplicate any benefits. I often analogize this to a sink with a cold faucet and a hot faucet. They can have one on at a time, but they can't have both on at the same time. But they can turn the cold on, shut it off, turn on the hot, shut it off, and back and forth. Terribly annoying, and that's why people like Dave and I are very helpful when they're trying to do this, because we do our best to make life uncomfortable for them.
And just so it's clear, although there's no technical case law, when the statute was amended in Pennsylvania in either 1993 or 1996, and Section 322 was added, Section 322 does state that you can't receive benefits from two jurisdictions at the same time. So it is clear in Pennsylvania that there is the possibility that this exists, but the courts will not allow someone to receive Pennsylvania benefits while someone is receiving benefits from another state for total disability benefits. I have had the situation in the past where an employee is receiving New Jersey permanency for a prior injury. So let's say the injury occurred in 2021 and they have order approved settlement in New Jersey and they're receiving their weekly permanency award and they're back to work and they suffer a new injury in Pennsylvania. The court will allow the employee to receive not only that prior permanency, but also the total disability in Pennsylvania. In the one case, there's no question you're entitled to both at the same time. The one, because it's two different injuries. The argument I tried to make in my case was that the prior permanency plus the Pennsylvania rate took you over the Pennsylvania maximum. There's no case law on it. We didn't take it up, but the judge found that the claimant could get the PA maximum for the 2024 injury, let's say hypothetically, along with the New Jersey existing permanency award. That's the way it can work in Pennsylvania. Okay, so we kind of talked about this a little bit, the examples of concurrent jurisdiction, but this is the most important thing that our clients need to recognize to try to issue spot. Because as Jeff said, the key here is when an accident happens and you know there's an injury, to spot the issue of Pennsylvania versus New Jersey jurisdiction, or dual jurisdiction if other states early on, so you can do what you need to do to best manage the exposure from the outset. Okay, so just by way of example, if you're injured in PA, but you work at or from a New Jersey location, I gave the issue before. One of my clients, US Foods, has 2 terminals in South Jersey. Their workers are commuters. They're not over the road truck drivers. They commute to the Jersey location. They get their bill of lading or whatever they're supposed to do. They do their pre-trip inspection. They go out on the road for the course of the day and they return back and then commute home. If that individual gets injured in Pennsylvania, there absolutely positively is dual jurisdiction, because there's going to be Jersey jurisdiction, right, Jeff? Because the person was working and assigned to a Jersey location, and they're going to have Pennsylvania jurisdiction because they were injured in PA. That's classic. Same thing. Go ahead, Jeff. You want
Yeah, I was just going to say,
something?
and they don't have to be just these traveling folks. You could be an office worker, but you're over in Philadelphia at a marketing event or at a mandatory meeting. So you work for a hospital, or you're in an office setting, but there's an office over in Pennsylvania, or your client or bosses come on over, we're having dinner tonight and discussing X, Y, and Z in Rittenhouse Square. So it can be a special mission exception, giving rise to, exposure in both states, because both states would recognize off-premises injuries when you're performing something for your employer. So it doesn't have to just be a truck driver over the road person. It could just be running an errand at the request of your company over the bridge.
Absolutely true. And the second bullet, you're injured in New Jersey, but you work at or from a Pennsylvania location. That's the buzzwords in Pennsylvania are principally localized, and principally localized in Pennsylvania means that there's a regular place in business in Pennsylvania where the employee regularly works at or from. So using Jeff's example, the person works in Pennsylvania, they're asked to go over to New Jersey for something. It might have been a one-time thing, but they're injured in New Jersey. They get the protection of New Jersey law, and they get New Jersey jurisdiction. They get the protection of Pennsylvania because the employer had a place of business in Pennsylvania where the employee regularly worked at or from. Any difference in Jersey, Jeff?
No, that's easily, compensable or jurisdictional, easily be found in New Jersey as well.
Okay, so Jeff, I think so in this one, the employee accepts the job in New Jersey, but is injured in Pennsylvania.
Mm-hmm.
That gives you Jersey jurisdiction, right?
Yep. Yeah, the contract of hire would be in New Jersey. The case that I was referring to is a Raymore and Flanagan case. It's only about 5 years old, because before that decision, within the last 5 years, the case we relied upon was like 25 years old. And that was like, the injured worker accepted the job over the phone. So I tell clients, if they exclusively work in New York or exclusively work in Pennsylvania, but they live in New Jersey, and you don't want to take a chance of having New Jersey jurisdiction be a dual option for them, tell them, please come over. We want to discuss things with you. Have them come to your office in Pennsylvania or in New York. Give them the job offer in person, and accept the job offer in person in your state. Therefore, the contract of hire would be in those states, and they have no option for New Jersey because they simply live there. So, interesting scenario.
And the reason why we have the reverse isn't true is because just because you have a contract for hire made or accepted in Pennsylvania, that's not going to give you enough to get Pennsylvania jurisdiction, because what the statute says is it has to be, one, the contract for hire is in Pennsylvania, and two, the employee does not have a principal place of business. So it has to be contract for hire made in PA with an over-the-road trucker who just drives everywhere. That's the way the contract of hire law works in Pennsylvania. We talk about other rare situations. For example, as I said, in Pennsylvania, you can have someone who is an over-the-road trucker. They have no principal place of business, but if by chance they accepted their job in Pennsylvania, that results in Pennsylvania jurisdiction. You can have agreements in Pennsylvania where you can agree to have jurisdiction in Pennsylvania, and likewise, trucking companies can have agreements under the Pennsylvania statute that can place jurisdiction outside of Pennsylvania in the event there are sufficient contacts within that other state. That's the Nebraska situation that I'm talking about. But there are just some other little subtle nuances here and there which can warrant, for example, Pennsylvania jurisdiction. If you live in Pennsylvania and a substantial portion of your work is in Pennsylvania, that's another way you can get Pennsylvania jurisdiction, even if you're injured outside of Pennsylvania. Any like special rare circumstances in New Jersey, Jeff?
Well, I mean, just a couple of things I can think of that are unusual is I've had instances where the employer had the employees sign contracts that state, if you're injured, the laws of Texas apply. You know, and the person like lives and works in New Jersey, and the employer just wants Texas law to apply because it's, you know, much better for employers. The judges in New Jersey were not bound by that, and are not. They're not bound by contracts between the parties. You know, they're seen as contracts of adhesion, unequal bargaining position, little employee, big employer. They're going to be bound by the statute and the case law. And I did have one interesting case many years ago where unfortunately a correspondent was executed by the Taliban in Afghanistan. He worked for the New York Times, and but the contract of hire was in New Jersey, and they'd asked me about jurisdiction. I said New Jersey would provide jurisdiction, and it wasn't a good case to fight and take up, and they agreed with me pretty quickly. So those are some interesting situations with jurisdiction.
And just to reiterate, a very important point is that Pennsylvania law does permit those contracts to exist that Jeff said are not deemed enforceable in New Jersey. But again, you can't just fix jurisdiction in a certain state. There have to be enough contacts with that other state for that contract to be accepted by the judge. And like I said, I have one client who's done this. They're based out of Nebraska, and knock on wood, we haven't lost a case yet. And we've had a lot of them where the employee tries to get Pennsylvania benefits because they live in Pennsylvania and they're technically assigned to a Pennsylvania location. So interesting difference between Pennsylvania and Jersey there. It's right in the statute. Okay. This is another question that we get when the issue is identified early. And I'm going to give you the example that I use with US Foods, because that's the best example that I can give for consistency purposes. Then there are some other kind of bullets that we talk about where maybe if you don't have like a specific places of business in every state, where maybe you can decide what suits you best. But US Foods, for example, has 2 locations in Pennsylvania and 2 locations in New Jersey. And what we've talked about with risk management is, and they have stuff all over the country, obviously. And what we've spoken to them about is, if they have an employee who works out of a New Jersey location, they're going to accept it as New Jersey. If they have a person who works out of Pennsylvania, they're going to accept it as Pennsylvania. And the reason is they want to be consistent in their practices. They don't want to be seen as an employer who, whenever the situation is most beneficial to them, they then choose which state they're going to accept it in, because they don't want to have that negative impression in front of the judges. And that makes a lot of sense. That's what we suggest clients do when they have situations like that. Jeff, you want to talk a little bit more about kind of the nuances of maybe when there isn't that kind of employer who's got the multiple locations with truck drivers, and maybe there's some specific issues you want to consider?
Yeah, and you know, I want to follow up on one of the points you raised, which is a good one, which is if the contacts with each state seem similar, it's like a 50-50 deal, which one should apply. We do recommend that you choose the one that makes more sense, not the one that necessarily is better for you, because if you choose the one that makes more sense, first of all, it's less likely the injured worker is going to run right to an attorney in that other state. And that the attorney in that instance is going to say, what are you doing? You've chosen one that's good for you, but clearly the other state applies either better or should apply, and they don't even realize the concept of concurrent jurisdiction, because a lot of our adversaries don't think about it. Petitioners' attorneys don't think about it at all. But if you have the options, if you think medical is going to be crazy and you're concerned about a diagnosis of chronic regional pain syndrome, or whether or not they're going to get all these topical creams, et cetera, in a webinar that I went to recently that Dave and Ross Gorin put on with that huge exposure for ongoing pain management. You may want to be over in New Jersey because you control the medical treatment, you direct the care. It's funny saying that in the last few months, it's become clear to me that New Jersey, while you control direct medical treatment, the billing is outrageous currently, especially for surgeries. The bills are extremely high, and we don't have a fee guideline. Whereas in Section 314 of the PA statute, you have 114% of Medicare and Medicaid cap guidelines. The medical bills come in one side, they spit out the other side. You rarely have a dispute about the medical payments in Pennsylvania. In New Jersey, I get medical provider applications for pay me more than you paid me all the time. So that may not be as I guess, as an attractive feature of New Jersey as it used to be. We're seeing large six-figure charges now for surgical procedures in New Jersey. And I'm recommending to my clients, this is a little bit of an aside, enter into agreements and contracts with your favorite doctors and surgeons throughout the state of New Jersey on what you agree you'll pay for. And that second surgeon, the assistant surgeon, who ends up getting another 50% of the surgeon bill. It's crazy. But if you think of it as a long-term wage loss issue, New Jersey's probably better for you because you get to control when you cut off the temp, the indemnity. Because when the medical treatment reaches a plateau of recovery, you can cut it off. You don't have to file a petition to suspend, modify, or terminate. You just simply get to cut off the benefits. In Pennsylvania, you have to have a basis for doing so. You have to file a petition. So there are different degrees of which state might be more attractive than the other. But again, if it's 50-50, try and be fair to the injured worker. But we do often get the question of, why are they filing here? And they're filing here often because they have lost benefits entitlement in one state or the other. They've gone back to work in Pennsylvania. So Dave and his clients have stopped the temp because they're back to work. But they had a cervical surgery and they were allowed to work for 4 months because they're a high wage earner. And then they find out, hey, I can get this thing called permanency in New Jersey. Or they reach maximum medical improvement, get their temp check cut in New Jersey. Now they have no income, but they're not working. We don't have to pay them in New Jersey, even though they're not working. They're going to run across the bridge. Back when I used to do both states, the claim petition in New Jersey, in Pennsylvania, would also carry with it a penalty petition. And they would say, Judge, they should be penalized for not paying benefits in Pennsylvania. And I defeated that pretty much every time by saying, Judge, the client, the employer had a choice, and it was a clear choice, and they chose New Jersey. There's no nefarious reason they chose New Jersey. It was completely applicable. They paid temporary and medical under the Jersey statute. But yes, they were injured in Philadelphia that day. We will be switching benefits to Pennsylvania under the Pennsylvania comp statute, but it's not a penalty situation because of the current concurrent jurisdiction, and they made a reasonable decision right from the outset.
So,
Jeff, I just want to jump in here real fast. We do have a question going back to the question of jurisdiction. The question is, so to reiterate, if they only live in New Jersey, they do not get the benefits for New Jersey.
Yes, residence alone is insufficient. I think that's what I got out of that question. Yeah, living in New Jersey alone is insufficient.
And just to dovetail on a couple of things that Jeff said about this slide, the first thing is, similarly, if the person is back to work relatively quickly without wage loss, but there's an injury, even if the person's back to work light duty, if you can, perfect situation to accept in Pennsylvania. Why? Because you might have a little bit of medical to pay, but you're not going to have any wage loss. That person who's back to work light duty is going to have that entitlement at some point to permanency. And it doesn't matter if you suffer a broken arm and you're fine. I've broken plenty of bones. I'm fine. In New Jersey, it doesn't matter. Jeff can tell you. You break a bone, there's permanency attached to it. You sprain your ankle, it doesn't even matter. There's permanency somehow attached to everything. And even if there's not, you're going to settle it via Section 20 because it's cost effective and it makes sense. And the last thing I'm going to say, and Jeff's going to laugh and not going to mind, but he somehow thinks that Section 314 is the medical section of the Act. Section 314 is the IME section of the Act. The medical is governed by Section 306. But
That's
excellent
close.
try. Excellent. Anyway, okay. This is where, as we call, the rubber hits the road, right? Hopefully, what we've talked about before has been in large part a review, and you want to understand what happens and how we're strategizing in these cases. This is what Jeff and I are extremely passionate about because we love helping employers who have this issue. We know how frustrating it can be, and it frustrates us too, not only because of what you guys may have to pay, but also what this this employee is lucky enough to potentially get, even though that person's colleague might only be able to get a portion of that because the person's colleague only had Jersey jurisdiction. Okay, so here's what we see. We see the situation where it's an accepted New Jersey injury. The person's receiving temp, authorized medical treatment in New Jersey. Employee is nearing MMI. And if this person's represented, then the petitioner's attorney is telling the petitioner that when your doctor, the one who the employer chose, says you are at MMI, you are no longer able to get wage loss, and you're no longer able to get medical. And if they know that this injury occurred in Pennsylvania, they are going to call their attorney referral source in Pennsylvania, and they're going to give this case to them, and it is going to be a no-brainer Pennsylvania claim petition. We will have no defense to jurisdiction. We'll talk a little bit more about strategies in a minute to try to minimize things. If the person is receiving New Jersey temp and the benefit rate in Pennsylvania is lower, we can unilaterally change it to the correct benefit rate. If it's higher in Pennsylvania, we're not only going to have to pay the new rate, but we're going to have to pay the difference because the employee didn't choose New Jersey. We chose New Jersey, and the employee is entitled to the protection of both states. So they get the balance of what the difference was between Pennsylvania and New Jersey. And the most important part of this, as I state below, and we're going to talk about this in a minute, is unless we have a defense to the payment of wage loss benefits, we will be stuck paying total disability benefits in Pennsylvania. So what do I mean? If it's a situation where you know that there's dual jurisdiction, and you know that the person is reaching MMI, and you know that you're about to be able to stop wage loss and medical in Pennsylvania, but you also know that this person is entitled to the protection under Pennsylvania law, maybe you get an IME of full recovery. You ordinarily wouldn't do that in New Jersey, but maybe, and if that's not in the cards, maybe somehow, some way, you make a job offer so that when this person, even if they don't return, now this person comes over to Pennsylvania and we say, no, okay, they got their New Jersey benefits, but they don't get additional Pennsylvania benefits because we have a defense to the payment of Pennsylvania benefits. As I'll explain a little more detail, that doesn't always work. I'll explain that in a couple of minutes. But Jeff, talk about what we see in Jersey.
Okay, yeah, what we typically see in New Jersey, and I kind of alluded to it earlier, is the person receives their temporary total disability benefits in Pennsylvania when they're out of work and they're treating. But let's say, unlike many of the injured workers in PA who want to stay out as long as they can, they force you to do voc rehab and find another job for them or make a modified duty job offer. This person goes back to work. So let's say they're back to work full duty, doing their job, or they were given some permanent light duty job because the employer likes them and can accommodate them. Great. And let's say it's the same wages they were making pre-injury. So their ongoing stream of temporary total in Pennsylvania is at an end. But as often happens, they hang out with friends, neighbors, etc., or they're part of an employer base that has a very good, either a union shop or injured worker, plaintiffs' attorneys, claimants' attorneys who talk to them on a regular basis, and they know they're potentially entitled to some more money over in New Jersey because of X, Y, and Z reasons. One of the reasons we've discussed thus far that gives them Pennsylvania or New Jersey jurisdiction potentially. So they come over here and they file a claim petition in New Jersey, simply seeking permanency. And sometimes, as I mentioned here, it follows a compromise and release where they already got a lump sum award in Pennsylvania. And that is infuriating. So they've gotten a lump sum award over in PA. You think their case is settled, and then they come over to New Jersey and they file a claim petition. My clients, I've had a couple of these over the years and send it to me. Our firm didn't handle the Pennsylvania case, because if we did, we wouldn't have let this happen. But they send the documents to me. They say they can't do this, can they? I'm like, yeah, they can. They're different states, different jurisdictions, different types of benefits. So I've seen this happen before. One case, the compromise release document was very well prepared, and the defense attorney in Pennsylvania put in there, this settlement should have full force and effect on any other benefits, including the state of New Jersey. They did their best, but the other attorney argued, and my judge couldn't disagree, that that decision about a settlement, not the merits of the case, but the settlement, had no binding effect in New Jersey. They were absolutely right. It's a different award. I argue the similarities all the time. I did in that case. Fortunately, I had a very good judge who, even though he was a former petitioner's attorney, was pretty conservative when he got on the bench. And he looked at petitioner's counsel and he said, you can do this. Without saying it, he was basically saying, but this is rude. You negotiated $100,000 CNR in Pennsylvania, and now you're coming over here and you want another bite at the apple. I'll tell you what, you prove your permanency in New Jersey, but I'm going to give Mr. Newby $100,000 credit for any award that your client gets in permanency in New Jersey. And I'm guessing it's not going to be more than $100 grand. And if you don't like it, take me up on appeal. So I was able to settle the case for, a couple bucks, thank God. But you're not always going to get that lucky, because, as you know, the compromise release, that is a lump sum of future wage loss, whether it's total or partial. You get your 500 weeks of partial, you reduce it to present value or vocational rehabilitation efforts of what they could make, and that's the partial, and you decide this is the present value of that dollar figure. We'll pay 3 years of comp or 4 years of comp. These are the Pennsylvania things that Dave probably talked about earlier this morning in his mediation. There's no such thing in New Jersey. We're not on all fours. The permanency award in New Jersey is for loss of function. But what I've argued before, and the judges have felt this made some sense, there is no decision on this. There's no appellate law decision that says permanency is the equivalent of a lump sum CNR. But what I've argued is permanency, as you all know, is not paid in a lump sum. If somebody gets 20% for their back for a herniated disc, and that's $27,000, we don't hand them a check for 27 grand. They get, if it's 20% of partial total, they're going to get 120 weeks of benefits. Why is it periodic? I argue that it's akin to a partial wage loss because they're partially disabled. So I argue that there is a similarity between future wage loss being lump summed and the exposure for permanency being paid periodically. These are the arguments we try and make to make sure that we get credits for you so you don't get banged in 2 different states for the same claim. So that's that general release. They can sign whatever they want to in Pennsylvania. It's not going to be binding upon a judge in another state. So keep that in mind. That's why we try and do what we do and close these cases simultaneously.
Okay, so how do we strategize about this situation? Okay, this is premised upon a situation where there's an accepted claim under New Jersey law, but we know early on that there's Pennsylvania jurisdiction, so we're managing the case under both states, even though the case is technically only being managed in New Jersey, if that makes sense. We're managing the potential Pennsylvania exposure in the background so that you don't have, or you can minimize these dual jurisdiction issues. So the most important thing, because we typically don't see these cases right away, is that the claims professional needs to ascertain and identify this issue as soon as possible. It doesn't help if the first notice that we have of the Pennsylvania issue is the Pennsylvania claim petition after MMI and TTD has been stopped. The claims rep has to identify it so that we can collectively work together to help manage the risk. it's not a case you can, I mean, we're always willing to help with anything, but many claims professionals handle New Jersey and Pennsylvania. So if they identify the issue and they're aware of the Pennsylvania issues and they know how to manage a claim in Pennsylvania, they know how to do all of these things. They know in that one case, maybe they get an IME, and even if it's under New Jersey law, because they want to try to get an opinion of full recovery. Maybe they say, look, maybe you can make a job offer, because that might protect us in Pennsylvania down the road. And that's what I say here. The best way to defend eventual PA claim is to make a job offer. And so long as this precedes the Pennsylvania claim petition, we can use this as an indemnity defense. Now, going down to the last bullet, there's no case law on this issue. And I've litigated this issue several times. And I can tell you that with some judges, I have won the issue. They say, look, you got New Jersey benefits. They made a job offer. I find the job offer credible. You're not entitled to any additional benefits in Pennsylvania, at least no more wage loss benefits in Pennsylvania. The individual is always entitled to medical because they have the protection. We just have a defense to the indemnity. I've also lost this issue and had counsel fees ordered against my client because the judge said, you know what, you can make this argument, but it's akin to a suspension petition argument. You need to pay and you need to argue that the benefit should stop. But typically I have a conversation with my client and I say, look, here are the possibilities, okay? How do you want to manage this issue? We have this defense. And almost invariably, the issue is we want the leverage. We don't want to just pick up the case and start paying in a state like Pennsylvania where it's so difficult to stop the TTD check. And it's going to take the claimant a year before the claimant gets anything. Now the leverage is on our side. Now we have the leverage. And we're also holding the money. So maybe we get this settled quickly, give the person a couple of bucks, they move on, and you don't have this big problem that blows into something major. And this fourth bullet I already talked about, getting the full recovery opinion. But the most important thing, and I can't stress it enough, is that somehow, some way, the claims professional needs to identify this issue. Because if the issue is not identified early, or maybe it's just, I say this way, if the issue is identified early, you're in a position to manage the risk of both states. If it's not identified early, it's very difficult to pick up the pieces on the back end. Jeff?
All right, so similar to the concepts Dave was talking about, you know, how can we strategize the situation in New Jersey? So I have the case, and we're paying benefits in New Jersey. Couple things. One, if they come to New Jersey and they've already been paid wage loss in Dave's case, and they're getting that max rate at $1,300 and change, the first thing I'm going to do, if they're still paying temp, the first thing I'm going to do is say reduce the rate down to $1,100. And I rarely get pushback from the attorney, and if I did, I think the judge would back me up. And if they're filing a claim petition in New Jersey, I want New Jersey jurisdiction and New Jersey law to apply to that claim. So the first thing we're going to do is ding their rate. They're probably not going to come into New Jersey while they're still getting $1,300 and change in Pennsylvania. But I think I mentioned here, if they come over to Jersey after their temp ends, then what I want to do when I conclude the case is I'm going to argue for a credit. Because when we settle these cases, if we put stipulations on the record, one of the stipulations we put on the record is the average weekly wage and the temp rate. And if I said to the judge, the average weekly wage is $3,000 and the temporary disability benefit rate is $1,345, the judge is going to look up at me and say, what? There's no such thing. The judge, that's what we paid. The judge is going to say, well, that's more than the max. So I don't ever run into that issue. The couple of times I've been able to handle this favorably for the client is I get a credit for the differential and I get a credit off the permanency award. What I'm fortunate about is that case about 10 slides earlier from 1980 that says they get to maximize their benefits. Most of the New Jersey attorneys don't jump up and say, hey, judge, they're allowed to get the $1,300 and change in PA, and there's no credit for New Jersey. Now they're going to get a New Jersey permanency award. That temp rate in Pennsylvania is perfectly appropriate. There's no such thing as a credit. Oftentimes, the New Jersey attorney doesn't think of that case, doesn't think of the argument, but allows me to get a credit for the differential. And if it's $200+ a week for 60 weeks, I might be able to get a $12,000 credit off of the permanency award. Dave and I did this in a case, and it was really helpful when he was cross-examining their expert, because he and I discussed strategy before the doctor's deposition in PA. I mentioned to him, and he said, I will try and get the doctor to agree that the injured worker, the claimant in Pennsylvania, has reached a plateau of recovery. They've reached maximum medical improvement. Because in Pennsylvania, there's no red flags go up or no white flags go up. But maximum medical improvement doesn't really mean anything in Pennsylvania, but for maybe the ability to file a utilization review if they're having ongoing useless treatment. But in terms of their temp check, doesn't matter if they're maximum medical improvement or not. You still have to pay them. But in New Jersey, you don't. So if their treating doctor that you're treating with, because they chose their doctor in Pennsylvania, says they've reached a plateau of recovery in January 2024, but we still pay them temp, and then they come over to New Jersey and they file a claim petition in November 2024, I'm going to argue at some point in my case, I'm entitled to a credit for all the temp we paid from January going forward, because we overpaid them. They were at maximum medical improvement way back in January. Those benefits should be credited towards permanency because they weren't entitled to that temp in New Jersey. Again, there's no case law on this, but the judges in New Jersey and oftentimes the injured worker's attorney would sit down with their client and say, hey, you wanted both states, you got to live with it. You were at MMI, Pennsylvania had to pay you, New Jersey did not. Also,
right. we had a couple of cases like that, and it was great because the Pennsylvania claimant's lawyer had no clue of why I was asking about MMI, and all of a sudden, person jumps over to New Jersey, the person returns to work, they want to get permanency, and we have like at least an argument, and you have the settlement conferences in New Jersey, and Jeff's like, look, Judge, we have a 5-month credit here because the claimant's own doctor, who he picked, said that he was at MMI and he can't get TTD. If he wants Jersey permanency, he's got to take a credit for everything after the MMI. And that was a big deal.
That saves us a lot of money. So what was I thinking about the MMI issue? I know opposing counsel, oftentimes they want to move forward with the permanency examinations in New Jersey. Dave or my colleagues in Pennsylvania are fighting the Pennsylvania case, and they're still providing benefits and they're still getting treatment. And I will tell the opposing attorney or the judge, I'm not setting up perm exams, they're still treating. Because that's the easiest adjournment in the world in New Jersey, a continuance, is to say under treatment, under active treatment. It would take petitioner's counsel a lot of work and effort to jump up to myself and the court and the counsel and say, or the judge, they're really at a plateau of recovery. They've reached maximum medical improvement in Pennsylvania. I've spoken to my Pennsylvania colleague. I've looked at the medical records. They're really at MMI. Jeff can really move on to permanency because my client's reached the plateau. They may be able to do that. I resisted for a while because what we want to do is kind of starve them out a little bit and force that concurrent settlement. But we also give Pennsylvania the opportunity to argue that if they have reached maximum medical improvement, that treatment beyond that date is useless, unreasonable, and give it back on the medical exposure in Pennsylvania if they think they're ready for a permanency examination in New Jersey.
All right, let's talk about the settlement. We've got 5 minutes left and we know most cases settle. So this issue comes up for me a lot. And what I tell my clients all the time is you don't have to settle both Pennsylvania and New Jersey when there's dual jurisdiction. You just need to think about it. You need to think about whether the issue needs to be raised. And invariably, in kind of the more litigious situations that we discussed, invariably, you're going to want to settle both states. And when you do it, like when if the case is being litigated in Pennsylvania and I go to a mediation, I can say, look, Judge, we're offering $50,000, but it's contingent on either, and Jeff can explain if this is the way to do it or not, it's contingent either on the filing of a New Jersey claim petition and a withdrawal with prejudice, or if they want to take a fraction out of the $50,000 and apply it to a Section 20 settlement in New Jersey, then have at it. But these things have to be settled together. You're not getting paid on one without the other. And typically there is no issue in getting it done this way. The reason why I raise the issue of weighing the pros and cons is if you know the injury happened in New Jersey, but the person has always been in Pennsylvania, they live in Pennsylvania, they've been receiving Pennsylvania comp, they have a Pennsylvania attorney, you may be raising an issue that they don't know about by telling them you need to settle New Jersey also. So that's where you just kind of need to weigh the pros and cons and make a decision. But if the claimant's represented in both states and in one of these situations that we've talked about, it's a no-brainer, and that's the way to do it.
Many of the Pennsylvania workers' comp, especially Philadelphia area workers' comp attorneys, they have their brethren across the bridge. So they share cases all the time. They're aware of the concurrent jurisdiction very often and the availability of it, especially when it's obvious. You know, if there's litigating in Philly, but the injury occurred in Camden, it's obvious. So Dave's right. What we often do is the PA attorneys are settling the case for usually larger dollar figures under a compromise and release. And then I'll be contacted by Dave or Pat Cummings or Dawn Nicholson, because we a lot of us we share clients that have these transportation industry employees, and they will send it over to me and say, Jeff, get this closed for $5,000 under Section 20. I've settled for $75,000 over here. We're kicking in 5 more, and then they will reach out to their New Jersey brethren. I would tell them to file the claim petition right away. I file an answer denying the case, saying it's compensable in Pennsylvania, but denying jurisdiction in New Jersey. We reach out to the judge, tell them the scenario. I've never had an issue because under Section 20 of the statute, unlike PA with those lump sums, under Section 20, I have to have a basis. And one of the bases in New Jersey for Section 20 is jurisdiction. Even though we know they have concurrent jurisdiction, it's not like they don't have it, they do have it. But I argue jurisdiction is the issue that gives rise to the lump sum settlement, because frankly, the temp issues differ, the medical issues differ, there's permanency, there's no permanency, et cetera. So I argue because of the confusion of jurisdiction, we can lump sum it, and no judge has ever said no to us. And we've come in, we get these smaller dollar Section 20s in New Jersey, so you don't face that New Jersey claim petition for permanency after you think you've put the case to bed in Pennsylvania.
So anyway, that's our little spiel. We finished in just under an hour. Like we said at the outset, we only had one question. That is the last one, right? Yep. You only had one question, but if you want to, our emails are on here. If you have questions and want to reach out to us afterwards with questions, feel free. These are very fact-sensitive issues. We understand that. We're available for free advice. We love handling actual cases, but we want to help our clients out. And if you have these issues and want to pick our brain, please feel free to call us, email us, whatever the case may be.
Dave, I do think we have one question, and I do apologize if you did answer it.
Okay.
We do have a question. How would that work with attorney fees if they are repped and petitions filed in both jurisdictions?
So, I'll speak about it in Pennsylvania, and I mean, Jeff can edit this as he chooses, but, you're settling in both states and you're negotiating the settlement at the same time. I go to a mediation in Pennsylvania and I say, look, this settlement has to be contingent on the New Jersey Section 20. And, let's say we're apportioning $10,000 of the Section 20. Of $10,000 of $100,000 settlement via Section 20. So the $90,000 in PA gets 80-20, 80% to the claimant, 20% to the attorney. And Jeff, there's a $10,000 Section 20 in New Jersey. How does that get apportioned?
20%, but it's all paid by the claimant. So the attorney's fees under Section 20 are all paid by the claimant. But we can modify that. If the two attorneys are friendly and one's just doing the other a favor, you might say, instead of a $2,000 fee, I'll take $1,000 fee. And if it's an issue, we might say, you know what, we'll split the fee with you. It's $10,000 Section 20. We'll pay $1,000 towards your fee. The injured worker pays $1,000 towards your fee. It's not problematic at all, and not really a hurdle at all to doing these simultaneous settlements.
Right. The most important thing is when we have that Pennsylvania mediation for the New Jersey aspect of the case, if we need and want to resolve it, is part of that discussion. We don't want to resolve the PA case and have that New Jersey issue lingering out there unless there is a conscious decision to sweep it under the rug and hope that it doesn't come up in the future. Okay. Any last words, Jeff?
No, it looks like blue shirts are required on our website and today. It's all blue shirts. That's all we ever wear.
It wasn't
Thanks,
planned.
yeah, thanks everybody for coming. And again, if you want to follow up more after today, if you didn't hear something about this topic you'd like to hear from us, just reach out to us. We're happy to have a separate Teams meeting just with you and your team.
And we can also share, I believe, this presentation with others. So we will have a link. I guess you probably can share it too. I don't know how it works, but if you need a copy of this link for future reference, we can certainly get it to you.
Thanks, everybody. Kristen, Chelsea, Val, thank you. Dave.
Yeah. Thanks,
have a good
everyone.
afternoon.
Have a good afternoon, everybody. Goodbye.